So let's say you've updated your trust 5 or 10 years ago, and you're wondering, have there been any changes in the law that would warrant another update in your trust? Or maybe you're wondering if there's any changes in your family situation that would lead to needing to update your trust. So in this video, I'm going to talk about some reasons why you might want to come back to your estate planning attorney and look at your estate plan and maybe make some changes. Okay, so first let's talk about changes in the law. And I'm specifically talking about California, but a lot of the changes that we look at are all over the US. So we are still under the portability regime, which means that upon the first death, if you're married, you can port or transfer money to the surviving spouse. Yay! And we also have a very high estate tax exemption right now, which is about $13 million per person. So a lot of times people don't need what we call an A-B split in your trust. So if you're looking over your trust and you see that you have this split upon the first death, it's mandatory that it goes to an A trust for the surviving spouse and a B trust for the deceased spouse. You might want to get rid of that. You might decide, hey, I think I want to simplify my trust. And I actually have a video about this very subject. It's called, Should I Simplify My Trust? So if you're wondering about this, I suggest, or maybe your parents have an A-B split and you're like, I don't want to have to deal with that when they die. Take a look at that video and it'll tell you a lot more. All right, so most of the changes recently in the law, I have to say, do not apply specifically to trusts, but they really do affect trusts. And the big one in California that most, if not all Californians have heard of is Proposition 19. Okay, so this changed how a parent can leave a property to a child and retain the low property tax exemption. And spoiler alert, it's not good news. It's really hard, actually, to leave a property to your child and keep the low property tax exemption. I have a video on this all about Proposition 19, and I suggest that you go watch it. A lot of people are familiar with these laws right now, but that can be a really good primer. So how does that affect how you do your estate planning? Well, you might think, okay, I want to leave my property to my child, but now I know that the property taxes are going to increase. I need to leave more liquid assets to that child to make sure that they can pay the property taxes. Or maybe you just figure, you know what, the child's probably going to sell the property, because if I have a property that I'm paying $2,000 a year in property taxes, and when I die, that's going to go up to $40,000 a year in property taxes. They're not going to want to keep the house to rent it out if they're having to pay $40,000 in property taxes, most likely. I mean, maybe they will, who knows, right? But that might affect how you're leaving things to your children. You may not want to just say, hey, this property goes to this person and this property goes to this person. You might want to change things up a little bit. Okay, so another change in the law that's not specific to trusts really, but it really affects estate planning is Secure, the Secure Act. And we now have Secure 2.0, all right? So starting in 2020, there have been several iterations of these changes to retirement planning. So this also affects parent-to-child transfers of pre-tax retirement accounts like IRAs, 401ks, 403bs. So it used to be that you could leave a retirement account to your child and they could inherit it and they could stretch it out over their lifetime and only pay the income taxes on the amount, the required minimum distribution, the amount that they're required to withdraw during that time. Well, unfortunately, Congress made it more beneficial for people who are older and retiring. They get to keep more of their money, but going to the next generation, it's harder to pass that along. So what does that mean? So if you have a neurotypical child who inherits a retirement account, instead of having their lifetime to stretch out the benefits, they have to pay all the taxes within 10 years. And guess what? They can't wait 10 years to pay the taxes. They have to pay it prorated over that 10-year period. That's a new regulation that was passed. So not great news. However, the good news is if you have a child with special needs, they can still stretch out the benefits over their lifetime, even if they have a special needs trust, and especially if they do. So then you calculate the disabled child's life expectancy, and then you just have to take out the required minimum distributions, but those can stay in the trust. Another great regulation that was recently passed is you can name a charity as a contingent beneficiary, a backup beneficiary after the child has died, and you still get these stretch out benefits. There is some question about that. Does this work or not? You can get that, all right? So if you have retirement accounts as a big part of your estate plan, there are some people who have retirement accounts of $2 million, $3 million, could be half or more of your estate plan. You'll really want to carefully think about who are you going to leave those retirement accounts to, and because they don't go, you don't title them in the trust. You keep them in your name, and then you update the beneficiary designation. So how do you want those to go upon your death? It's a big question now. And I have a video, of course, called How to Fund Your Special Needs Trust with Retirement Accounts. All right, so I suggest you watch that video for more details on this.
Hey everyone, if you like my mom's video, like and subscribe.
Now, there will be some other changes in the law going into 2024, but they're not very major. The estate tax exemption is going to go up a little bit more. And most likely, the annual exclusion amount will probably go up from $17,000 to $18,000 a year. That's how much you can gift as many people as you want during the year and still not have to pay gift taxes and not have to report that to the IRS. But what about changes in your family situation? Let's talk about that. Okay, so I suggest that people usually come in to talk to me or to talk to your estate planning attorney when there's been a major change. So let's say that a member of your family has gone through a big life change. Maybe there's been a birth in the family, yay, or a death. Maybe somebody has gotten married or someone's gotten divorced. These are all situations that really do warrant a check-in to see, do I need to change anything? Maybe you got a pretty bad diagnosis. I've had a few clients die from cancer this year. Okay, so when you get that diagnosis, come on in. We really want to make sure that everything is up to speed on what you want. And I always want to put in the plug that you should check to see how your assets are funded. Make sure that your bank and brokerage accounts are properly titled in the name of the trust. Make sure that your house is properly titled in the name of the trust. Whenever somebody comes in for a check-in, that's one thing that we look at. We look to make sure that everything is funded properly. I think of a trust like a basket. Okay, if things are not in the basket, it doesn't work. What's the good of a basket if you don't have things held in that basket? I have a video called Funding Your Trust. And so you can look at that video and make sure that each type of asset that you have is properly either titled in the name of the trust, or the beneficiary designation is updated, or maybe you need an assignment from you to your trust. We'll look to see. Other changes that might have happened in your family. I know during COVID, a lot of families were hit pretty hard with mental health challenges, especially if they have young adults who were kind of borderline getting out into society. There's been a lot of failure to thrive. A lot of people have regressed in their mental health. If that's been your situation, I suggest that you come on in. We can talk about planning opportunities just to make sure that your child has the right scaffolding around them, the right protection. So if you're not there to protect your child, if you're not there to make sure that they have the right housing in place, that they get the meds that they need, that they have all the services that they need, the job training, then somebody else is there to help them with that. So remember, we call it a revocable living trust. Your trust is supposed to live with you. It's supposed to change. It's not like you just sign it once and then you put it on your bookshelf. Although I know a lot of people who do, but you really should take a look at it and make sure that it comports with your wishes. We like doing flow charts. So you could even just look at the flow chart that we had provided a few years ago and say, does that flow the way that I think it should? Let's think about that. When you come in, there's two different types of changes that you might need to make. One change, if you've worked with us before, for example, and you're coming back to make a change to your trust, we could do a partial amendment. So we just amend a little paragraph in the trust. So let's say you left a portion to, a $50,000 gift to your nephew, and then you guys had a falling out and you decide you don't want that. We can remove that from the trust just by revising the trust just a little bit. Now, we don't do small revisions to other attorneys' trusts, because when we do work on somebody else's trust, we're taking on all of the liability of that trust. and it takes us much longer to review that trust and make sure that it's up to snuff. So if you want to make just a little revision to your trust, you should go back to the attorney that you were working with before. Otherwise, the other way to make an amendment to your trust is to do what we call a restatement and amendment. Okay, so we keep the trust title the same, but we update the insides. And what's really nice about this is if you've funded your trust already, which you should have if you have a trust, you don't have to retitle those assets. So what does that mean? You don't have to record another deed to confirm that the house stays in the trust if you do a restatement and amendment. You don't have to do that. We keep the title the same. So if the title is the Smith Family Trust 1997, we keep the title the Smith Family Trust 1997. We just call it the first restatement and amendment of the Smith Family Trust 1997. Okay, so you see how that works, so that the title stays the same, but we restate, we amend the entire insides. And one nice thing about that is upon your death, whoever is entitled to a copy of the trust, which we describe in our trust administration video, okay, whoever's entitled to that, they're only entitled to the part where it starts at the restatement and amendment. Okay, so if there's prior versions of the trust document, they don't get that. They get just starting at the restatement. So it's really good in several different perspectives to do a restatement and amendment. So I hope that this has given you some food for thought on what updates you might need to do in 2024. So as you look over your trust documents, as you think about your family, think about, okay, what's the very best thing? And please give our office a call or call your estate planning attorney. They would love to help you with this. We like having a relationship with our families for their lifetime and then for their children's lifetime if they're open to it as well. So please come on in and we'll help you work on it. So thanks so much.
Hello everyone! If you liked my mom's video, don't forget to like and subscribe. See you all next time!